Hi, I'm Ken Fossen. Today we have a superintendent's question about a clause in a contract. We're having a fundraising event at the high school next month, and I've been presented with a standard contract from a company that will be providing the food and entertainment at that event. In reviewing the contract, I see a paragraph titled Waiver of Subrogation. What is that? Is it important? In order to understand the implications presented by the Waiver of Subrogation clause, let's first discuss what subrogation is and how it works. In our question, we have two parties, the school and the contractor, entering into a contract. If all goes well, the issue of subrogation will never arise, for subrogation only comes into play when something goes wrong. For example, the contractor causes a fire that damages school property. If this should happen, the school will turn to its insurance company. The insurance company will then pay the school for its loss, let's say $100,000. When this occurs, the doctrine of subrogation comes into play. When the insurance company pays the school for its loss, the claim the school district had against the contractor is then subrogated to the insurance company as a matter of law. You can think of subrogation as something akin to an automatic assignment of a claim. As a result, the insurance company now has all of the rights the school district had to recover the loss from the contractor. So the insurance company is able to sue the contractor for the loss and get a judgment for the $100,000 it previously paid to the school district. So that's how subrogation works. Now what happens when the contract between the school and the contractor has a waiver of subrogation provision? Well, if the right of subrogation is waived, the claim of the school district does not subrogate to the insurance company, so the insurance company does not have the right to bring a lawsuit against the contractor to recoup the $100,000 it paid to the school district. At this point, you're probably thinking, so what? The school got paid, so who cares? Well, here's the rub. The right to subrogation is the insurance company's right, it's not the school district's right. Therefore, the school district does not have the authority to waive that right, unless of course the insurance company gives it permission to do so. If the insurance company should decide to give the school that authority, it would do so by adding an endorsement to the policy stating such. So, in our fact situation here, the worst case scenario for the school district would be for the insurance company to take the position that the school district's waiving of its subrogation rights constituted a breach of contract and therefore the company was not obligated to pay for the $100,000 loss. On the other hand, the best case scenario would be that the insurance company had already added an endorsement to the insurance policy, granting permission for the school district to waive the insurance company's subrogation rights. So why would an insurance company ever agree to permit a policyholder to waive the insurance company's subrogation rights? To answer that question, let's examine this hypothetical. Let's say the school district has the need for some additional storage space, so it leases some space in a commercial warehouse that has 10 bays plus an indoor delivery space. The school leases bay number 3 and all goes well for a few weeks. Then one night a fire breaks out in the warehouse and everything is destroyed. The devastation is so complete that the fire investigators are unable to determine the precise cause of the fire. However, they are of the opinion that it likely originated somewhere near the center of the building. In this hypothetical, there could be as many as 11 different insurance companies involved, one for each of the 10 tenants, plus one for the warehouse owner. After the fire, the school's insurance company would pay the school for its loss and would then be subrogated to the claim the school would have against the party who caused the fire. Similarly, the other 10 insurance companies would pay their policyholders and would be subrogated to their tenants' claims. Just imagine the number of claims and counterclaims that could conceivably result from this fact situation. The cost of pursuing those claims through litigation could far exceed the value of all the property lost in the fire itself. To avoid this, the warehouse owner could have taken a different approach and required that all of the warehouse contracts include a mutual waiver of subrogation clause as well as a hold harmless clause for all parties. Under the mutual waiver of subrogation clause, both parties would be waiving their insurance company's right of subrogation. To comply with this provision, the school would need to get an endorsement for the waiver from the insurance company, unless, of course, the endorsement had already been added to the policy. So, under this new contractual arrangement, if a fire destroyed the building, the insurance company for the school district would cover the school's loss, while the insurance company for the warehouse owner would cover the owner's loss. Since the contract contained a mutual waiver of subrogation clause, there would be no litigation between the insurance companies because their subrogation rights had been waived. Similarly, because both parties agreed to the hold harmless clause, they could not pursue individual claims against each other either. And the same would go for all of the other tenants. Their contracts would also contain mutual waivers of subrogation and hold harmless clauses. So the end result would be that each tenant and the owner would be paid for its loss by its insurance company regardless of who was at fault, and there would be no costly litigation to follow. Since the costs incurred by insurance companies to pursue their subrogated claims can be so expensive, the practice of automatically adding an insurance policy endorsement permitting waivers of subrogation in contracts has actually become more common in the industry. You'll need to contact your agent or broker to see if your policy has such an endorsement. So what do you do if you have a proposed contract with a waiver of subrogation clause in it? Contact your insurance agent. You may already have an endorsement on your policy that covers it. If not, see if it can be added, hopefully without any additional premium. You will also want to contact your school's attorney to review the waiver language because it could contain some significant exclusions or limitations. You will also want your attorney to examine the contract for any other provisions, like a hold harmless clause, that should be reviewed in light of the waiver of subrogation provision. As was mentioned in an earlier session, try to get your attorney and your insurance agent on the same conference call so that everyone is in the loop. You know the facts, the agent knows the policy, and the attorney knows the law. It takes all three working together to arrive at the best approach to the issue. I hope this was beneficial. Thanks to the attorneys at the Perry Law Firm for assisting in making these videos possible, and of course, thanks to you for watching. See you next time.